To our last panelist, Steve Gibbons. Before I do, let me just remind the room that at the end of when Steve has finished, we're going to be closing the list for questions. So please, if you have a question you'd still like to get on there, please do come up to the Secretariat at the front and put your name down. Steve, last but not least, turning to yourself, Steve is the founding director of Ergon Associates, a specialist consultancy working on labour and human rights and a variety of related issues. And Ergon was both the designer and, in the end, the manager as well of a really unique and unprecedented mechanism. The London Olympic and Paralympic Games had the first sustainable sourcing codes of any Olympic Games, and attached to that sourcing code a complaints mechanism for breaches of the code in the supply chain, supplying Olympic branded goods. So this was a first, and I think there's much hope that it will be a precedent for future Olympic and Paralympic Games and other major sporting and other events as well. But Steve, kick us off with giving us an idea of what this mechanism looked like in practice.
Okay, thanks very much. I thought for a moment you were going to say after Steve we're going to reinstate the reception, but that's only hoping as far as that. At least I'm not holding you from alcohol here. So I think the first thing to say, and you said the mechanism was unique. The first thing to say about an Olympic Games is it's an absolutely unique event. It's astonishing. Certainly when we first started working with them, and I've worked with a range of different sort of public and corporate organisations, it took us months to get our heads around what they're actually doing. Now, this might be because nobody knew what they were doing, yeah, but it was all right on the 4 weeks in the summer. But it's phenomenally complex, and it's complex and unique in the context of being, an incredible sporting event. It's also an incredible entertainment event. It's also an incredible commercial opportunity for those companies who are fortunate enough, because most of them are fortunate as a result, to be one of the limited commercial partners of an Olympic Games. It's also unique because of the light that can be shined on a range of factors. Now, as far as the kinds of human rights that we're talking about at the Olympic Games is concerned, as you said, the grievance mechanism was attached to the sustainability code. So in theory, and we did get one or two, we could have complaints about recycling, complaints about food, complaints about environmental standards, but nearly all of the complaints were about labour standards in the supply chain. And this is where I come back to the uniqueness as an opportunity to shine a light. And there's some people in the room who've been involved over the years in excellent campaigns, both from NGOs and trade unions, to demonstrate the conditions and working conditions in particular in factories supplying for licensed goods or procured goods for Olympic Games. And it's an opportunity for that campaign. Now, there's a uniqueness. The other side to that is that the working conditions in that factory aren't that different, to be quite honest. The fact that you're producing the fantastic mascots, as my daughter calls them, the strange one-eyed things, as I call them, is if you're producing those 1 week, but the next week you're producing for Disney. Now, I'm not going to make a public comment on those working conditions, but it doesn't change because it's the Olympics. It's the transparency and the openness that changes. So what was decided as far as actually London 2012 is concerned, and this did not, and I think we can say this, did not come from somebody within the organising committee of the Olympics. This came because of stakeholder pressure. It was because of campaigns and behind closed doors negotiations and discussions between trade unions, NGOs and the organising committee, not only to adopt the Ethical Trading Initiative base code as far as the normative standard for production, not only to do some monitoring and work with its commercial partners, whether those be Next, a UK company, or Adidas, big international company, or Honav, Chinese pin manufacturer, in order to carry out audits as far as the factory is concerned. We all know the limitations on audits, but what's more, that there would be some form of complaints and grievance mechanism. Now, this is where we first came in. We won a public tender in order to actually devise that mechanism and ended up managing it. Now, one good thing for the Olympic ticks is concerned, I think we were one of the few local SMEs that won a contract, and that was one of the commitments of the game. So there we are, tick number 7. But what we did in order to devise that, and in the earlier session in this room, people saying a lot, and it's certainly in our consulting practice, a lot of big multinational organisations, once they look at human rights issues, they say, well, we've got a lot of things here. You know, we can do a lot of things. We can build on policies and procedures we've got. With the Olympic Games, remember, this is the biggest Phoenix company in the world. It went from nothing in a year to $1 billion plus in a couple of months turnover company, and will be in administration liquidated finito in April next year. They had no policies, they had no people. So we had, in many ways, we're building from scratch. So we looked at other big events. There hadn't been a big event that had this kind of mechanism. We talked to Caroline, we talked to her colleagues, we talked to NCP, we looked at all sorts of alternatives. We talked to stakeholders. We went out and we talked to the UK affiliates of the Clean Clothes campaign, the trade unions, a range of others, to actually say, well, you are going to bring a complaint. So we almost solicited, anticipating they would, you know, what do we need to do to make the complaint mechanism workable? So as far as actually the design principles that we used for devising the mechanism, and I won't go into lots of detail because next week, for those who want to read it, there's a whole range of case studies going to be published around sustainability and these rights elements about the Games. But first of all, we said it has to be built on the responsibility of the workplace itself. Now, there's some challenges there, but you shouldn't be doing this at 3,000 feet. You should be trying to build sustainable change, which means that workers, either through preferably their trade unions or if not through other mechanisms, should be able to raise these grievances in the workplace and get a response. Yeah? We also had to recognise and respect channels with independent trade unions for these complaints. We didn't want to put something in place which actually got in the way of that or actually undermined that. But also we had to acknowledge the profile of the Games and the likely complaints that would come and the effect on the Games. Our commercial client was the Games. So we had to say there will be complaints. Some commercial partners, you know, I've mentioned one, Three Stripes, won't say the name, they have mechanisms, yeah? They have procedures, they've got lots of fantastic experience on this. Other commercial partners had no experience whatsoever. But in either case, there was always going to be pressure, and this is why it's unique, on the Games to do something and to show it's doing something. So we had to have a mechanism that scoped complaints, but first of all then looked for the commercial partners and the complainants to clarify information, provide information, and suggest solutions. We pushed all the time for dialogue around solutions. And then really, in many ways, it was a last resort sometimes when this would come back to LOCOG, this is the organising committee, to actually do something. And that would, on some occasions, would be investigation, but in other occasions, and I can give some further examples if we want to and move on, would be to move into much deeper dialogue rather than trying to supplement existing state or workplace mechanisms. We try to move sustainable change by talking to people, which sometimes was really hard work. It would have been easier to send in a team of classic auditors to come back with an answer. Yeah? But we knew that wouldn't work and wouldn't actually deliver a long-term result.
Thank you, Steve. We'll just dwell on that for one moment with us, if you would, because, of course, you could have investigated and focused on investigations and findings and corrective actions and so on, but you say dialogue was seen as harder in process terms but better in outcome terms. Can you say a bit more?
Let me give two examples of, there was probably three broad types of complaints. And I'm not saying we had lots and lots of complaints, yeah? But three, thank goodness. We had three broad types of complaints. One was the individual worker, which, for example, in China, and I'll explain why in a moment, where lots of production took place at the key times running up to the Games. Because remember, we were on very short time frames. This wasn't like working with a brand and say, you build capacity, you build involvement, working with, you know, local stakeholders. The leverage point was very small. And also the chaos and pressure within LOCOG to get things fixed quickly was also very short. So we had some complaints which were from individual workers through, we'll call it hotlines. It was hopefully it was a bit better than some of the hotlines. This is not that we see, but from individual workers. And in those circumstances, quite often, and also in relation to press complaints, on the first weekend of of 2012, with lots of pressure going up to the Games, we had, of course, newspapers saying about the mascots and how the mascots were being produced. Yeah. So then I had to explain to my 7-year-old what I was going to be doing that day with those fantastic mascots. But there was no way we could have dialogue in the factories in China with the complainants in order to solve that. Mainly because by the time we got to that point, Lunar New Year had happened, predominantly migrant workers, they'd gone home, and also the complainants, which was a combination of NGOs and press, couldn't tell us who those were. And obviously there's an issue as far as negotiating with Chinese trade unions over that kind of remedial action. So in those circumstances, we took much more of an investigation route to find facts, but then we entered into dialogue with the commercial partners, including the factories and the intermediary sort of commercial partner for LOCOG and LOCOG, and with international Hong Kong-based and international trade union organisations to talk about systematic change. So we had investigation, but dialogue about remedy. Another example I'll give, and I think all of these are public domain, well, at least I hope they are, related to complaints in the Philippines. Now, the point about the complaints there, they weren't so much those individual working hours, sort of contract complaints we're getting on the QQ from China, but were more systematic about trade union access onto export processing zones, about wages, about the things that if you work in this, they don't get fixed in the time frame of an Olympic Games. So more of the issue there was whether we could actually use almost the good offices to start a dialogue. And the way that we did that, and it was hard work, and for my sins, I mediated that personally on request of the parties, but we had parallel mediation over a period of time to get the parties to a point that they could be in a room together. And what we did in that parallel mediation was to have a dialogue around rights. So we had to make sure that the framework we were talking about was rights compatible, but everybody was agreed on that framework. And once we got to that, we started to move a little bit. But then we got to go to the Philippines. Before we got there, there was a condition from the trade union side that if there was going to be a mediation on the games mechanism, then the brand involved had to encourage other brands to be involved in a parallel meeting the day before, or the day after, I've lost track of time by now, is in order to talk about the systematic response across the whole sector. So on this one, the effective dialogue, and actually the remedy that they wanted was sector-wide dialogue, even though the complaints were about two factories. And I think this, for me, this was a challenging, but the outcome still ongoing. And what we've tried to do now is hand that over to the Labour Ministry to play the mediator role for a more sustainable outcome. But that was a really good example whereby if you ask people what you want, and your dialogue is not just about getting a rights-based solution, but it's about asking people what they want. And in these circumstances, what the unions wanted was a door to start a discussion. Whereas, again, with Chinese workers, quite often when you ask them, when we circle back and said, what do you want really? And they say, I just want my money and out of here. Yeah? So I think there's a combination of investigation and dialogue is what we did there.
That's terrific, Steve. Thank you. And evidently many more interesting lessons to come out of that. But I want to open this up now for discussion in the room as a whole. I'm going to ask Alex Guaqueta to kick us off with the first question. But just before I do, Alex, just to remind the room about our ground rules, as it were, for questions. We have 2 minutes for each question. Again, just a courtesy to make sure that others have the opportunity to raise issues as well. So please keep an eye on me and I will gently and politely indicate if we're passing the 2-minute point. Again, please avoid the set piece statements. Please do be interactive with what you've heard on the stage and be pertinent to the topic. In the event that somebody really wants to follow up directly on something that's just been raised, I will allow that. Please raise your hand, and if time permitting, I'll take 1, maximum 2 hot pursuit questions to keep us interactive. But I'll just have to manage that based on time, and I'm keen we also make sure we have a spread of stakeholder inputs as well. So again, just as we do this, let's keep this good spirit of respect and tolerance. These are always issues that raise different viewpoints, so let's just keep that as part of our ground rule too. I'll ask that when people do ask questions, please say who you are and what your affiliation is at the beginning. That's quite enough from me. Alex, give us your thoughts and question.
Sure. Caroline, thanks so much for organizing this panel for the forum, and thanks to the panelists. Now, 2 quick questions. And I would like to hear from the panelists. What are the main challenges to feed results back into company management systems and make sure that problems don't repeat themselves? That is, turning a remedy into a prevention tool. So what works? Because ultimately, that's what we want. That's what I would call the sustainable the sustainable change. Now, the other one is on the issue of remedy itself, the elements that make remedy effective. So sometimes complaints are processed, agreements are reached, but then communities or workers come back and challenge the agreement, even if the process was solid. So what would be the top elements of effective remedy for you?
Thank you, Alex. I'm going to see if anyone from the panel wants to respond immediately on that point. Otherwise, we'll go on and gather a few more points and perhaps come back to it. I know sometimes good to have a moment for reflection. And any takers immediately? Yep, Hege and Loretta. Okay, Hege.
I think to the first question, to get a sustainable change, the key is for the management to see the mediated outcome as a process rather than as a ending station. And regarding the second question, communities challenge the agreement, is to spend enough time at the outset to map all the stakeholders. And there may be stakeholders that you wouldn't think of in the beginning, but that suddenly end up being quite important. And in one of our cases, we had the 3 NGOs in the room and the company. And the company was there with their CEO, with their lawyer, and then we identified some issues that were not well-based, so they were refuted, and the NGOs agreed to that. So one of the NGOs left the room, and then everything got quite tense, and it was really, really hard situation. And then we decided to bring in one of the staunchest critics of the company by video conference. And it was this environmentalist from the Norwegian fjords. And suddenly we had a situation where the environmentalist expert was talking directly with the CEO. And suddenly the whole thing fell into place. And there was a moment where the lawyer of the company was, getting very uneasy. But the CEO, just did this movement, and he said, "It's okay. We can apologize to these guys. We can admit that we're wrong." And actually, after the conclusion of the case, there hasn't been any litigation. And even though there are still tough issues remaining, the parties still build on the mediated outcome.
Thank you, Loretta.
For some reason, there we go. I think certainly for a human rights institution, we didn't have a formal mechanism for ensuring that those lapses didn't happen again, but regular monitoring. And I recognize that that isn't something that's available for every grievance process, but as a Human Rights Commission, we monitor regularly. We produce a State of Human Rights report each year. It's not focused on the mining community as that one was, but I think that spotlight that was shone on their activities, for a period, sort of remains there in the background. I don't think that companies would want to suddenly be back to being the focus of a human rights report. So we found that has kind of that's played a role in keeping those particular types of violations. There are others that were not subject to mediation, such as reports of excess force being used by security personnel. Those, for example, we did not mediate because we didn't feel that they were the appropriate subject. We took some decisions, and those I think require formal structures. Things that basically are flags such that if anything like that happens, you report it. But for the mediated outcomes, we found that monitoring has played a role. And sorry, in terms of the actual elements, as I say, in our particular cases, they were very often financial. It was about redress. It was about improving living conditions, improving situations that had arisen directly as a result of those violations. And sometimes it was actually about not the opposite of getting financial recompense. We had a situation where a company who had contaminated the water had set up taps and were charging the community a notional amount, but we're charging them for, access to this water. And it was more a question of having them understand that, no, do you realize that this is as a direct result of your operations? You have changed the life of this community, and you have to try and put them back in the situation they were before, where they had access to clean, free water. So I think that's the other thing about mediation, if I can say that process of dialogue can change minds in a way that taking judicial action and making a determination might, you might have to go back to judicial action later because you haven't had that process of dialogue for them to understand why these rights needed to be dealt with.
Thank you, Steve.
For us, the issue of actual sustainable change within companies was inevitably sort of one of the major challenges, partly because of the time frame. Because basically, as soon as Danny Boyle convinced the Queen to jump out of a helicopter, two things happened. One is it accelerated the end of the British monarchy, hopefully, and the other point is that LOCOG's leverage over its supply chain was finished. Because LOCOG phoning up a factory and saying, will you sort this out, didn't work anymore because they said, we delivered this to you 3 months ago. So in order to deal with that, what we tried to actually work on was concepts of transparency as much as possible. And on the two types of complaints I was talking about, as far as actually the investigation complaint, there was some issues as far as transparency because of the commercial confidentiality around the supply chain, et cetera, But what we tried to do wherever possible is that those agreed outcomes that were coming from the investigation with dialogue were communicated widely, were made available to the off-takers from that factory, and where possible to off-takers more broadly than just those working around the Olympics. And obviously, were wherever possible shared with Rio. That's a small part, but it's one part. As far as the dialogue-based outcomes, we worked with the trade unions and the communities there to actually try as much as possible to say to them, the outcome is you understanding what has been agreed, and actually you understanding that we're not going to be around, and it's your responsibility now to actually take that forward. And hopefully working with actually national governments as well was really important there to try and build that in. So it's as much openness as possible, I think, from our perspective.
Okay, thank you to our panelists. Now, what I'm going to do is read out the first 5 names I have here so everybody knows who's coming up. And we'll take 5 questions under 2 minutes, and then I'll come back for comments from panelists in response. So the first on my list is Winan Kredliak from BIAC, the Business and Industry Advisory Council. Then I have a representative of OECD Watch. I have Gina Barbieri from the World Bank Group. I have Dwight Justice from the ITUC, and I have David Wooford from the Meridian Group. So that's our first cluster of 5 questions. Winan, if you could please speak next. Thank you.
I have a question which is, I think, mainly addressed to Hege. Until now, we have been focusing on company behavior and complaints about company behavior. And I would like to introduce a totally different dimension in the discussion, because there are also a number of cases in the framework of NGO campaigns, trade union campaigns, where companies have complaints about the way that those NGOs or trade unions behave. And this is an element which is also recognized by John Ruggie, where he has been speaking about frivolous campaigns. So there are now a number of NCPs which have opened the possibility also for companies to bring into discussion such complaints about behavior. In the Danish NCP, it has been formally introduced. Other NCPs have been discussing it. Would you consider introducing such an element in the Norwegian NCP? Thank you.
Thank you. Thank you, and I can see this is going to be a fun discussion we're going to have. The representative of OECD Watch, I'm not sure where in the room. Joris back at the back there. Please, Joris.
Hi, my name is, does it work? Yeah. My name is Joris Oldenziel. I'm from OECD Watch, an NGO network that is specifically looking at the OECD guidelines for multinational enterprises. And we have been analyzing the cases that have been brought forward by NGOs under the OECD guidelines for more than 10 years now. And one of the problems that we find is that actually mediation often fails. And Wienand Kwaadvlieg has just mentioned that according to him, sometimes the NGOs are acting in bad faith. Well, in fact, we see that very often companies are unwilling to enter into mediation on reasonable grounds. And therefore, I see really a big gap in the access to remedy pillar. We have, on the one hand, the other working group, the breakout group on access to judicial remedy, and here the one on non-judicial remedy. But I think the focus is too much on mediation only. I think we also have to look at a strong non-judicial grievance mechanism that actually has teeth, that has a power to investigate, and that has a power to adjudicate and to also sanction. And you could think of something like which in other sectors is much more common, like a competition authority that has actually the powers to do investigation on their own initiative, and if there's a problem, to sanction. Because very often affected communities need a very clear independent statement from an authoritative body, not necessarily a judicial body, but an authoritative non-judicial body. So I would like to bring that into the discussion and see what the panelists think about that. Thank you.
Thank you very much for that question. Third on my list, I have Gina Barbieri from the Compliance Advisor Ombudsman's Office of the World Bank.
As Caroline mentioned, I've managed the dispute resolution arm of the Compliance Advisor Ombudsman that's been mentioned by a number of the panel members there. And I've got a question and a comment. One question around accessing the independent accountability mechanisms. How do we improve our accessibility for communities and work with those communities to build their capacities to engage with us effectively? Because otherwise there's just no point in us existing. So that's the first question, very particularly on international access to grievance mechanisms. And then secondly, around implementation of negotiated outcomes. So I'd be interested to hear from the NCP, Norwegian NCP, on what their role is in monitoring effective implementation of outcomes if you're working in jurisdictions where access to judicial recourse is ineffective, and that's simply why they've come to you in the first instance. So how do you loop back those negotiated outcomes to an effective mechanism to ensure enforcement? And then lastly, just a comment. I wondered to what extent we are having the debates on dispute resolution and accessing third-party neutrals in the second pillar, the duty of business to protect, because by the time a complaint comes to a grievance mechanism such as ours, it's really late in the day, and the damage in most instances has already been done. And what we're looking at is a mediation or a remediation effect or impact. It would be really useful to give some thought to how do we incentivize the private sector to embrace dispute resolution really early on alongside communities, and not see management of communities simply as a risk to be managed, but as a part of the shared value of a project. Thanks.
Thank you, Gina. And Dwight Justice from the ITUC.
Microphone for the speaker.
29.
Could you turn your microphone on, please?
In the commentary to Principle 29, it states that operational level grievance mechanisms should not be used to undermine the role of legitimate trade unions in addressing labor-related disputes or to prevent access to judicial or other non-judicial grievance mechanisms. And we heard from several operational level grievance mechanisms that were dealing with labor. And so my question would be, to what extent was this taken into account, and were unions involved? But more importantly, I think we need to think about a concept of due diligence with respect to these kind of mechanisms, to make sure that in the process of setting them up, we're not actually violating human rights. So an example of that would be the timing. If the workers are organizing a union, well, maybe when you set up a grievance mechanism at that point, you're actually committing a human rights violation. You're not following the Ruggie principles. The second thing I wanted to say is, generally, I didn't hear from any of the speakers anything about the effectiveness criteria that you see in Principle 31 of the guiding principles. And I think that in these kind of discussions, we need to start looking at whether the criteria for something credible, because my concern is what's going to happen now is the regular complaints mechanisms that have existed forever will now be dressed up in a disguise. And what we really need to be doing is see whether we're actually building something that fits what the principles are, instead of declaring them or anointing them. You know, it's hard to believe, but 20 years ago, this year, workers in the Cater factory in Thailand were dying from a fire. And in the course of that, we met with some of the trade associations. And, you know, they proposed a grievance mechanism. And that consisted of going to them before we went to the press. And I think we need to make sure that that's not what we're doing here.
Thanks very much indeed, Dwight. And a final question in this cluster then for David Wofford from the Meridian Group.
Hi. My name is David Wofford. I work for a small women-owned business that deals with worker health at the workplace and gender and issues like that. And I want to follow up on the IFC comment, because a huge part of this is obviously critical about grievance, non-judicial, and judicial kinds of remedies. But in fact, you know, there are many mechanisms out there in health and other worlds where you're not dealing with trying to fix something, but you're trying to change things for the better, that has incredible impacts on human rights. And I wonder how the working group and what the panelists think about trying to think about other sectors that are outside of human rights that have ideas or processes that are about, you know, companies asking and talking to their workers, not purely about grievance, about a problem, but basic worker communication or stakeholder communications. I realize that exists, but I feel like the guiding principles often are about dealing with the worst, which is incredibly important, but there's a huge proactive agenda that can help companies play a role in ameliorating and improving, changing gender rights and other things. It isn't just about protecting, it's about taking active role in change. So I'd like to hear the panelists' thoughts on that.
Okay, thank you for 5 very good questions. I am going to ask our panelists to pick probably the 1 or 2 questions that they feel are most pertinent to them, and to give us some quick thoughts on that, because I want to get at least 1 more round of questions in before we have to draw to a close. Natalie, I'll start with you, please.
Thank you. First, Gina's question about the CAO and describing how access to remedy through non-judicial grievance mechanisms like the CAO can be more effective by getting the information out that these mechanisms exist. I think it's very much an all of the above answer, that there need to be initial disclosures as part of project contracts where companies are required to discuss through their due diligence process with communities that international level grievance mechanisms exist. It's a very different answer for project level grievance mechanisms, which in my view, and going back to Principle 31, actually they must be developed in consultation with the affected communities for them to be legitimate, because as my colleague from Papua New Guinea who's here knows, every community will have its own way that they need to resolve disputes, and one cannot be imposed on them when access to remedy is at stake. So initial disclosures for international level, the mechanisms themselves, the CAO does an excellent job of outreach with the resources that you have to do outreach, and you're, I think, one of the better mechanisms in terms of making an effort to have an outreach program. And then also NGOs. As I said, we're one of the only organizations in the world. We're very, very small. There needs to be a proliferation of NGOs working to get the word out that access to remedy can exist for communities affected by projects. And I'll just briefly touch on Joris's point from OECD Watch about having teeth. And my comments did focus on mediation, but Accountability Council brings complaints on behalf of a number of communities who have no interest in mediation whatsoever, because for whatever reason, often if they cannot go to a court, they are using a non-judicial recourse mechanism, even though they were designed not to be a substitute. They're necessarily needing to be a substitute because there frankly is nothing else that they can use. And in that case, on occasion when human rights are violated, the bell has been rung. You can't unring it. What they want is a finding of fact that their rights were violated, some vindication of their own rights, and fact-finding with teeth is a critical element of that. And then finally, I just wanted to weigh in on Principle 31. Again, I think those effectiveness criteria are key, but I do think they're missing one thing, which is independence. And the international level grievance mechanisms in particular can build in independent ways of operating, as can project level mechanisms, and that's something that I know we don't have time to get into, but just wanted to plant that response.
Thank you. Hege. Thank you. So regarding the first question from Biak, it's a very good and interesting idea, and Norway has volunteered to undergo a peer review next year. And I would like to invite you to submit that into our process so that can be looked at whether we should change our procedures more according to what the Danish are now doing. Regarding Joris' question, OECD Watch, that too much emphasis is put on mediation, and that a lot of companies really don't want to mediate, and that it won't work. And then I would like to remind us all of the wise words said by Loretta, that the asset of the Ghanesian mechanism is that you can speak softly, but you carry a stick. And that is what is unique about the OECD National Contact Point system. We are both in Pillar 1, the state duty to protect, but we're also in Pillar 3 as a grievance mechanism. And we are tasked with, we are mandated to issue final statements. And just a final statement by anyone wouldn't carry that much clout as something that is endorsed by the state as being in Pillar 1. And the Norwegian NCP last year issued 50 pages final statement after we had conducted fact-finding. We had in fact hired a social anthropologist to go into the mountains of Mindoro, an island in the Philippines, to interview indigenous peoples. And we also had environmentalists coming in and looking at the issues. And we had 233 footnotes that cited all the facts that we used in the case, and there are copies at the back of the room of this one. And at a desperate moment, the lawyer of the company called me, threatened to sue because the company was having problems in financing, and they got a lot of bad publicity when it broke in the news. But later that evening, I got a tiny small email from an indigenous people's representative in the Philippines with a lot of misspellings in, it was a mix of different languages, and I got help to translate. And what it basically said was that they're very grateful that we had looked at that case and that they could use this as a way of expressing what they really needed in safeguarding their interests in the process.
Thank you, Hege. Mike.
Well, I'm going to respond to just one question that actually caught my attention. It's about mediation feeling, and there's always a focus on mediation, and how to incentivize companies to actually engage in much more than mediation to resolve conflicts immediately. I'm going back to my experience because it's something that something that's probably very fundamental. Mediation is a process, is part of conflict resolution process. It's one of the things that we can do. But on an operating level, companies should already have basic grievance mechanism that would act as a some sort of a valve that would allow the company to early on catch issues and address them as they are reported and as they happen. And this is really something that that should be a commitment of corporations. This is something that should be established as part of the culture, as part of the values of the company, to address basic human rights issues as they happen, as you operate, as you do your activities, as you start your due diligence, as you progress towards your project. So you don't even need to incentivize companies to do that because there's an inherent value to it. Number one, it addresses most of the issues that I think the Sakhalin Group has experienced. Less court cases, more issues resolved, and at the end of the day, when you have an effective grievance mechanism at an operating level, your social license is maintained. Something that you really have to work on. It's something that's continuous. It's something that you need to renew every time you do something. And I think that's the best benefit of having a grievance mechanism in place on an operating level.
Thank you very much, Mike. And just before I ask Loretta to take the microphone, as with every session today, I've been informed that we can run over a little since we started late. So we will run to sort of 6:15 or 20 since your reception has been cancelled. So it's compensation, right there. What can I say? We will, however, lose our sorry, we will, I know. We will lose our interpretation, I know, at 6 or very soon thereafter because our interpreters have to leave. And so I will try and get that extra round of questions in before then. And just so that people in the room know, so that you don't leave thinking you're lost off the list, that next round will be the representative of the research group on private and international law and human rights, Roper Cleland from IPICA, Inika Zeldenrust from the Clean Clothes Campaign, Nili Savavi from BP, Serge Bronkhorst from Access, and Catherine Koemans from Mining Watch Canada. So 6 more very brief questions, and we'll be wrapping up by 6:15. So Loretta, I apologise. On to you.
Sorry. I'll also just address one question from OECD Watch. Certainly, I absolutely agree. I mean, mediation that has some teeth behind it, stands a better chance of getting a result that will stick. But I think for us, the way we look at mediation is as the tool to get the remedy, not as something that determines how we get to that point. So, just speaking for Shraj, but I think other human rights commissions that perform this role, we do investigative work. We did a very extensive investigation over several months for these particular violations, interviewed a lot of people, and made findings of fact. And I think that's important to have those, that's teeth right there, to have those findings on the record. But then in choosing, what one will do with that information, whether to, based on the finding, make a judicial order or make a recommendation that needs to be enforced in court, or whether one goes with those facts to the company and says, it is clear that this has happened, but let's see how best you can sort it out. So I think I wouldn't want any of us to feel that, mediation is intended as a way to soften the results that one wants to get in terms of protecting these rights. We were just looking at what's going to be the best tool, and to get something that will stick. And as I know I've said it already, said it before, but there is that risk with businesses where violations are coming about in the normal course of their business, that if you just make an order, 2 years later, 5 years later, it will happen again. If it is with mediation, you've sort of already got a template that if this is going to happen, well, take care of this, compensate, provide, do these other things, and if at all possible, avoid these events happening. I think the mediation process has built in it the possibility for long-lasting changes. Thank you.
Thank you. And Oleg?
I would like to reply the question about the criteria. Actually, it is a very important issue, especially for those people who are in charge of implementing the framework mechanism of processing grievances, how to measure the effectiveness and efficiency of the procedure. I will rely on our experience of the Sakhalin project as a KPI. As one of the KPI, key measurement points, is the percentage of grievances that were processed and reviewed on time. They have to be reviewed within 45 days from the time when the grievance was lodged. This KPI is a public responsibility of the company, and this is one of the KPI that is used to measure, to calculate the additional salary for all company employees. Our KPI is about 95% of grievances that were reviewed within 45 workdays. It is one of the KPIs. But actually, in reality, we have sought the expertise of different experts who are experts in processing grievances in corporate environment. What other KPIs could be found? The business environment and the business community needs the experience and assistance of the international community and international institutions. What other KPIs could be put forward as initiatives which could serve as a specific criteria? The percentage of grievances which were reviewed by the consent of the person who is submitting the grievance, without the consent of the person who is submitting the grievances. And of course, we have to compare the number of lawsuits and the number of grievances that were lodged. However, the issue of criteria is an essential issue, but we haven't found a specific reply. As far as our experience goes, how do we judge that the mechanism and the framework has been proven effective? We have external monitoring. Once a year, we are checking and verifying all social responsibilities of our company. We have about 850 social functions, and for instance, the grievance processing mechanism is one of the functions. The entity that is in charge of monitoring create false grievances. They call us the hotline, they lodge a grievance, and then they trace how the grievance was processed. We do accept anonymous grievances which were lodged by telephone, by internet, or in person. And in order for us, for you not to waste the time, please look up the information on www.sakhalinenergy.com, where we have information in English, in Russian, in Japanese, including the statistical data on grievance processing. Thank you so much.
Thank you very much. And Felipe, I know you might want to address the trade union point as well that was raised. Thank you.
Well, I just want to say something about the role of the unions in our process. Well, I think it's a very particular case of Mexico, but we have a huge problem with the unions in Mexico, because almost all of them are ghost unions, even all of these big union centrals. Yeah, centrals. But we have some a few groups of legitimate unions, but when we want to involve these kind of legitimate or real unions, in our process, the most of the times the companies don't want to talk with them because they have an unjustified afraid about this kind of unions. But actually in Guadalajara we have a coalition of workers, and we do many pressure to the companies for because we think that it's necessary the dialogue, the direct dialogue between the companies and this coalition, because the coalition is real union, real workers group, and he knows what the workers want. And regarding to how to make more sustainable and this kind of process of mechanism, I think that it's obviously necessary the direct dialogue between the companies and the workers, and I think if the companies accept to talk directly with the unions, it will be a very big opportunity to do our mechanism more sustainable. Yeah, thank you.
Felipe and Steve, very briefly, a couple of pickups from your side.
Okay, and I'm going to talk as well on the union issue and try and address that. I mean, as far as actually design of the Olympic Games mechanism, unions were involved from the outset. As I said, they were in many ways the instigators as they went to the Games and asked for that. And also they were sort of indirectly involved, well, they were directly involved as complainants throughout, but an important thing I forgot to mention as well on the design, we also had a critical friend throughout the process, and Caroline was one of those critical friends, more friendly than critical most of the time, but is that was a stakeholder oversight group, and that stakeholder oversight group had a range of people, and Fiona Gooch hopefully is somewhere in the room as well, who's another member of that group, but we had people who the trade unions nominated, a former trade union official academic who had trading experience, to bring that view inside the tent as we're dealing with this all the way through. So I think we did try as best as possible to do that. On your specific issue, Dwight, as far as grievances and freedom of association, I think you're absolutely spot on of the issue. Quite often, you know, a grievance, which is a good thing, a workplace grievance is a good thing, can be used actually as a union busting technique in order to actually put in place a grievance mechanism to say, you don't need the union, we'll listen to you through the mechanism. Now, I think the important thing to take this forward is, one, to look at the standards that are around. And if you look at the equivalent normative standards, it's only actually, I'm going to look over there, IFC Performance Standard 2, which I think very prescient, said that there should be workplace grievances, but also put the rider, exactly the point you said, that they shouldn't be used to undermine genuine worker representatives. And I think this comes to the next point as far as the guiding principles generally. Freedom of association, and I speak as someone who has worked on it for a long time and continues to work on it, it is never easy. And one of the issues, certainly as far as business representatives in this room and business representatives we work with, there is a low level of understanding. It's almost something new, well, you deal with it simply. It's very, very complex. And I think for those of you who haven't seen it, the publication that ITUC and Industrial launched this morning.
Excuse me, message from the interpreters. Interpretation service is finished.
Is a really good start. And I think it's worth actually building.
Have a good evening.
More about issues about freedom of association, because it's one of the most complex human rights and most important human rights that we can deal with.
You, Steve. Now, the other thing I have to tell you is that we may be losing your filming, so if you were aiming for the Cannes Festival or anything, you may no longer be on camera in the last 15 minutes of our session. Apologies for that. I'm going to ask for a really quick whisk around now, both by our questioners. Can you even try down to 1 minute if you would? And I'll be asking again our panel to be very, very brief. So first of all, the representative of the Research Group on Private International Law and Human Rights.
Thank you. My name is Nicolás Zambrana, and I am a representative of the Research Group on Private International Law and Human Rights. And my question is addressed mostly to the representative of Accountability Council and Ergon Associates. To what extent could non-judicial remedies be coercive or enforceable, and to what extent, beyond mediation, other alternative dispute resolution mechanisms, such as arbitration, could be used? Or to what extent could agreements reached via mediation be enforced? Obviously, arbitration needs consent by both parties, and I would like to know if you can think of any scenario where a corporation may give its consent to submit to an arbitration tribunal, which can issue an enforceable award at the end of the proceedings. Thank you very much.
Thank you very much indeed for your brevity and clarity. Ropa Cleland from IPICA.
Thanks. I'm from IPICA, which is the Oil and Gas Industry Association for Environmental and Social Issues. It's been very helpful to hear from Oleg, Felipe, and Steve about the benefits of organizational level grievance mechanisms and the need for a fit-for-purpose approach. IPICA has also developed some good practice guidance on company level grievance mechanisms, which I have here. And these are aligned with the UN guiding principles. So my question for the panelists is how you see these efforts aligning with higher level national and international non-judicial processes.
Thank you very much. Ineke from the Clean Clothes Campaign.
Thanks. I have a question for Steve and then one for the group. Steve, you talked about the difference. The differences between the Chinese complaints and the Philippines complaints. And then you very quickly said there had been some issues around commercial confidentiality and the disclosure of the supplier lists. But from our perspective, it seems that given that Adidas actually disclosed its supplier list quite timely, in time enough for the Philippines complaints to be well developed, to be filed in time, and to actually have been developed together with the workers. Well, the other companies did not disclose their supplier lists. That meant that the Chinese complaints indeed came late because working groups had to actually find those factories themselves. Would you agree that if there would have been a full and timely disclosure of the supplier lists by LOCOC, that could have made a big difference in terms of the outcomes of those complaints? And then you also mentioned that some of the remediation could actually not be happening or could not take place because LOCOC's function had ended. But, well, again, one of the demands that has been made on the side of the unions and us is that actually the situation would need to be within the IOC. And it should not just be a handover from now onto Rio or to another games, because it's quite, even for, even if you have no pre-knowledge, it's quite obvious that the IOC actually has the continuation and has therefore the possibility to settle grievances, and each organizing committee is only there for 3 or 4 years. So what recommendations will be made by you to the IOC to prevent this problem in the future? And then
questions out of 3.
I was on a minute.
Well, thank you. I think we need to move on, but thank you. 2 good questions for the panel. And Nili Safavi from BP.
I'm going to try to use this microphone. Okay, great. So thank you. I just wanted to ask a question related to best practice. So as mentioned by Ms. Bridgman, quite a few companies have had operational project level grievance mechanisms in place for quite a few years. And within BP, I have social practitioners on the ground coming and now asking, okay, what do we need to do to align with the UN guiding principles? What do we have to do differently? And you mentioned independence. So I was wondering, if I asked the question, could you spend a little bit of time talking a little bit about how those operational project level grievance mechanisms can become more independent? Thanks.
Nope. Thank you very much. Serge Bronkhorst from Access.
Thank you, Caroline. My name is Serge Bronkhorst. I'm director of Access, new facility and global resource that supports dialogue-based resolution of company-community conflicts. And in some of these non-judicial processes, we will need to involve a professional mediator. And well, my question relates to Ms. Silos and Bueno. Where did you find your professional neutral mediator in your processes? Thank you.
Thank you very much. And our final question from Catherine Coumans of Mining Watch Canada. I'm
afraid this is a bit of a series as well, but just a couple of quick things. One one of the problems with NCPs, and this would be for the Norwegian NCP, which we think is one of the models, is that there is no consistency across NCPs. And so that people from different countries are going to face different circumstances. And some of the really important issues here are that not all NCPs will do an independent investigation of the cases that have been brought. And not all NCPs will even give a statement of fact of whether or not the guidelines have been breached. And that's very problematic. But also a real problem with the NCP system is that there's no funding for the mediations across most NCPs. So you can have an NCP decide that something can go to mediation, but then not have any funding to actually have the mediation happen, which is always harder on the people bringing the complaint than it is on the company. Beyond that, just more broadly, a concern I have with mediated or non-judicial grievance mechanisms as opposed to grievance mechanisms, judicial grievance mechanisms, is the fact that in a non-judicial grievance mechanism, the company has an inordinate amount of power. Even with a state-based mechanism in Canada, we've had 3 complaints brought. In two cases, the company simply walked. It said no, they didn't want to play, so they walked. So there was no remedy. And even when the company is willing to play and get into the mediation, the company has ultimate power over what remedy it may provide, if any. And so it puts the people who have been harmed, who are alleged that they've been harmed, into an untenable position where the person who's been harmed has to go to the company that has harmed them and basically beg for remedy, and have very little power around being able to force that remedy. And the company has ultimate power in that situation. And particularly at the project level, I think this is really problematic. I think a lot more thinking needs to be done around project level grievance mechanisms, because there's less transparency that's not happening on an international level. There's less likelihood of having international support, such as Bridget can provide. And it's sometimes more dangerous because people are having to complain when they're in their actual communities. And then I just have one question, which is that it seems to me that non-judicial grievance mechanisms are always going to be weaker where it's the only option, where there isn't a judicial mechanism as an option. So that if people can go to court and then they voluntarily decide to try mediation first and see if that works, they're in a much stronger position than if basically there is no effective judicial remedy. So that's it.
Thank you very much. Well, look, we have a rich array of questions there. I'm aware we have 1 or 2 or maybe more very indulgent interpreters still at the back. Can I ask whether we still have Russian interpretation? We do, we don't. No, we may not. We may not. Okay, I apologize. I was going to suggest that Oleg go first if we still had Russian interpretation. Look, what I'll do is I'll take it in reverse order. We have 10 minutes, so I think that's somewhere like 1.5 minutes each. We can't do justice to the questions. I'm sorry. If you can just pick those that really were directed at you or you feel you have the most to say on. And Steve, start us off very briefly.
Okay, there was 2 that are relevant there. I think one was the question of enforceability as far as issues are concerned. Now, as far as supply chains are concerned, it's difficult, but I think there's one issue of enforceability. I won't talk about arbitration, it's too complicated at this time of day. But was the issue actually, quite often there was enforceability, and you would see it in a supply chain context, in the contracts between the brands who are sourcing and the factories. Because essentially there is a contractual enforceability there, but and we'll move on to a moment, there's a privity of contract between that brand and its factory. So what we tried to do, and what LOCOG did on a number of occasions, we use the mechanism, but not the mechanism for this as well, which I can't talk about or I would have to kill you, is to say that when LOCOG was threatening to withdraw its business from a partner on the basis of human rights grounds. And it was the contractual nexus that was used for that enforcement. I don't know if that helps at all, really. That's the only one there. Inika, we can probably talk about this later rather than all the issues there, but I think there's 2 issues on disclosure. I think you're right to raise that issue, that one thing that changed the game a little bit, that's my first sporting analogy, I've tried really hard not to do them, was to actually that Adidas and then other commercial brands and partners disclosed where the production was taking place. And as far as actually the NGOs and the trade unions and the international groups, that meant that, of course, you could go and we know it and find complaints which then came to the system, which was a positive process there. I think that's one thing, but that wasn't, and I agree with you, and I think it's a lesson from the games which presumably you'll be taking back to say, well, lots of people disclosed and the world didn't end. which was a key point for this. But the thing I was talking about more was the fact, was the commercial confidentiality between those, let's say if there's an audit, there's an inspection, there's an outcome that isn't in the public domain of a commercial partner of LOCOG, but they're disappearing. So let's say it was a toy manufacturing company, right? Golden Bear was the only, I can say the name, was the only manufacturing company, a British company there. Those factories, another company is more likely to be sourcing in the future from there. I won't say its name, but it owns a Magic Kingdom, right? Now, as far as that is concerned, what we couldn't do there was to say, here you are, you can see everything that went on during that investigation. That's more of the point that I'm saying. In other circumstances, it could be. On the IOC, I think we probably talk about it outside. Yeah.
Thanks so much.
Oh, well, I will try to answer. Sorry. I will try to answer the question regarding the intermediator. No, but well, I think when you try to find an intermediator, I think that the person who you choose must know about the problem, and they must have contact with all the parts, and they try to be neutral, but sometimes it's a little bit impossible, because sometimes the problem is very obvious, and you have to do even the right things. But I don't know. Maybe this is one of the most important things when you try to find an intermediator, no? And obviously the capacity to talk with each part and to find a solution, an equal solution for the both parts.
Thank you, Felipe. And Oleg, I apologize. I'd love to have you respond as you would like, if you would mind, in English, because I fear we have lost translation at this point.
Okay, I'll try. But as I told you before, my English far from the perfect. Frankly speaking, when we're talking about the mediation, we in the company do not reach the final decision about it. In some of cases, we invite the mediators and experts, especially in the cases when we have a discussion about the compensation, because the compensation, or in situation in involuntary resettlement, for example. But in one case, we think that mediation must to attempt. It's case about indigenous. For indigenous, our company have developed a special grievances procedure, and upper body who is who must close the grievances. In normal situation, it's Business Integrity Committee led by CEO. As for indigenous, we have set up a special body where majority of voices belongs to indigenous. So indigenous, in case of indigenous grievances, are real mediators. So company do not have majority in these voices, and frankly speaking, it means that we trust to indigenous to solve the grievances related to indigenous themselves. Sorry for my English.
Not at all. It was very clear. Thank you, Oleg. Loretta.
Sorry, I don't know why. I'll also just address, just speak to one question, the comment from Mining Watch. And again, agreeing with Oleg, I do think that mediators, for it to be an effective mediation, I don't think that usually that one would say that the company gets to decide, you know, what it will give or what it will accept, because, you know, if they accept the idea of mediation, there's meant to be a mutual agreement at the end about the settlement, you know, that whatever is the final decision amount, whatever. I don't think we look at it normally as the company deciding. But I do think that where a company walks away or right from the beginning says that they're not interested, again, back to very quickly, you asked me earlier how do we decide whether to use our judicial remedies or non-judicial, where we have an intransigent company, where they're not open to us doing the kind of investigations that OECD Watch was talking about, where they're not open to us getting access to information that we need, we don't choose mediation. Then we say, well, okay, let us, you know, wield the stick, as it were. So you know, I do think that the mediated settlement, if you've equalized by having a voice, and that's where human rights commissions can play a role. You know, you can get an effective solution. But also, just very quickly, let me just clarify that in terms of how to ensure that these continue, when I was talking about monitoring, that this for us is how we rely on ensuring. It's not monitoring the companies. I'm sure that other companies would have been horrified to think that, you know, that that's what one would propose as a way to make a mediated solution effective. We monitor from the victims, you know, the communities later on, and just check how are they doing, are we hearing of more violations. And I think that that's something that's available outside of human rights commissions. Any mediator group can sort of keep up a watching brief for a year or 2 or 3 or 5, and I think that that keeps a company on its toes.
Thank you very much. Mike?
Yeah. Carol, I will address the question. I will address the question that was directed to me. The complaint regarding our acquisition of Amuklang Biha were filed with the Compliance Advisor Ombudsman. And they sent an investigation team to conduct an assessment of the validity of the complaint. And certain issues were actually raised or elevated during that process. Now, the process of appointing a mediator is not the choice of SNWIT's power. However, once presented, all the stakeholders were actually consulted on whether the mediator is acceptable to everyone. And as a process, the agreement or the consensual process of appointing that mediator was done through the CAO, the Compliance Advisor Ombudsman, which I believe is an independent body directly reporting to the World Bank Board.
Thank you very much. Hege.
Thank you. The problem relating to different NCPs doing their work differently, that is I think you expressed some concerns on behalf of a lot of civil society, but actually I think that also a lot of companies and business associations have the same concerns. The business would be concerned that there would be forum shopping, that the NCP, some NCPs receive all the complaints, and that NCPs then would have an uneven playing field. We are working 4 ways to address these issues. We do it in specific cases. So we have NCP collaboration, and the Norwegian NCP has worked closely together with Canadian, Chilean, North African NCPs, and UK, Netherlands, South Korea, and by discussing real issues, that is also a way of sharing ways of tackling different issues and doing things. Second way, annual meetings. We actually have 2 annual meetings. I don't think the word annual meeting then covers it. Thematic meetings is the third one. Norwegian and UK and Brazilian NCP are planning an event next year. We also, that's just one example, but the Norwegian NCP has cooperated with ICMM, International Council for Mining and Minerals, and the Institute for Business and Human Rights concerning extractive industries, and to listen to how NCPs can meet the needs of both civil society and business. And the fourth way is through peer reviews. Last year, Japan was the first to undergo a peer review. Norway was asked to head the delegation of NCPs, and a number of other NCPs are undergoing peer reviews next year. And there was a question regarding mediation, that it's expensive and some NCPs don't pay for it. In the latest mediation case that the Norwegian NCP is handling, we went out on tender to find the right mediator in consultation with both the company involved and with the civil society. And we ended up with the cheapest one. That was a retired Supreme Court judge, and he didn't want to have anything.
Very good, thank you. And Natalie, finally.
I'm going to answer the two that were directed at me as I saw them. One is regarding coercive grievance mechanisms. I think there is an absolute danger if a grievance mechanism, especially at the project level, but at the international level it can happen as well, and I've seen that and been part of that. If it's not designed well, a grievance mechanism can be coercive, and it can even go to the point of causing the mechanism's staff, mediators, to be complicit in perpetuation of abuses if that power imbalance that I discussed earlier is not addressed and worked into the design of the mechanism so it's a fair and equitable process. And those are, of course, two of the elements in Principle 31 of the guiding principles. In Mexico, I have one sunny story to share. As a human rights lawyer, usually I'm Debbie Downer, but I do have one positive story to share. In Mexico and Oaxaca, the communities I represented were challenging a large hydroelectric project that was going to destroy their access to clean water, and the accountability mechanism in question, the parties, together with the company and the operator, designed a process, and the communities, their main concern was transparency, because everything in this project had been done in secret. So they designed a process where the Mexican government was present as a witness to every single stage of the negotiation, from the beginning of the negotiation, even of the ground rules, to the concluding agreements at the end. And we did reach a conclusion, an agreement, a positive agreement in that process. So I can go on about that, but I won't. In terms of best practices for operational level grievance mechanisms, there has been a good deal of work done by the CAO, by the IFC. I think another tool was mentioned that was done recently. But in terms of the independence issue, which is the one I raised, that is, I think, the one missing from the guiding principles, there are a number of ways that can be done. One is that the community and the company, to the extent that there's kind of an ongoing relationship, and this can be done at the outset, can mutually decide who will resolve conflicts. It could be an esteemed person in the community, it could be a retired judge, it could be a think tank. There are lots of ways to draw in professionals with experience in dispute resolution to help work at an independent level. The problem is always going to be who's going to pay for that, because that part of the independence is always going to be tricky, because the communities, by definition, will usually be the vulnerable group that can't pay. But there can be indicia of independence built into the agreement with the company about how that payment happens. And again, I can go on, but we can discuss it afterward. I know we're out of time.
Thank you so much, Natalie. And in the interest of time, and I think also reality, I'm not going to try and sum up what's been an extremely rich discussion. I really thank everybody for the high quality of the questions and comments, raising some really rich and fundamentally important questions about these kinds of mechanisms and processes. And I know Alex Guaqueta has indicated that she wants to go away and think hard on all of the things that she's heard here, and how the UN Working Group can take forward some of the thinking and key principles raised. So please just join me, if you would, in thanking our panelists for their wonderful contributions, and thank you to you.